of NIIGPM Nagpur. I would like to welcome respected Director Dr. Rajesh Kesh. I would also like to welcome Head of Mechanical Department Dr. Santosh Raja sir, Coordinator R&D Cell and Professor Mechanical Department OIST Dr. Jitendra Pandit sir, and all the faculty members of OIST Bhopal. The R&D Cell of Oriental Institute of Science and Technology Bhopal aims to develop the research ability among their faculty members and students. Importance of research and development has been magnanimous to fulfill and cope up the new challenges of society, either in terms of technical or non-technical. The Research and Development Cell has planned these series of expert lecture in and around of research from basics to higher levels. We believe that these lecture series would definitely help our faculty for their research works. Our expert today, Shri Nirmalaya Sinha, is working for more than 19 years plus in central government office under the Patent Office Ministry of Commerce and Industry, and presently working as Joint Controller of Patents, Design and Head of Office in NIIGPM Nagpur from 24 November 2021, which is only central government national IPR training institute in India. He has completed his BTech in electronics from Nagpur University in 2001, MTech in materials engineering from Jadavpur University, Calcutta in 2004, and he has also completed his one-year executive program in business management from IIM Calcutta. He has joined Patent Office in 2002 as Examiner of Patents, Designs, Group A, Gazetted Officer, and he has been promoted to Assistant Controller of Patents, Designs in Patent Office in Delhi in 2009. And he was shifted to Patent Office Kolkata in May 2011 as Group Leader of Electrical Group. And he was promoted to Joint Controller of Patents Design in NIIGPM Nagpur and joined here on 24th November 21 as Head of the Office. He has knowledge of foreign language like French, Spanish, Russian, etc. He has delivered many lectures on IPR in various parts of the country. He was deputed twice for training at European Patent Office, the Netherlands, and the World Intellectual Property Organization, Geneva, Switzerland, on examination CDIP issues respectively. Thank you, sir, for accepting our request. Now, I would like to request our expert to start the session.
Yeah, good afternoon to all of you, and thank you, Dr. Jitendra, for inviting me to address your esteemed institute. And we will shortly start a presentation on patents and copyright. And our institute has been offering, our institute at Nagpur is the only training institute of Ministry of Commerce and Industry regarding patents, which is in dissemination of knowledge relating to intellectual property rights. And we are regularly conducting public training programs, which are generally on paid basis. And but this current program is a free program. And however, if you want to know, we will offer you a basic knowledge about patent and copyright. However, if you want to know in depth, then you have to enroll for our public training program, which is paid. And from time to time we offer it. If you come to our website ipindia.gov.in, you will come to know about our public training program, and we request you to enroll for it if you want in-depth knowledge about these topics. Sir, I am not allowed to share my screen. Will you give me the permission?
Yes, sir. Yes, sir.
Yeah.
Sir, your screen is not visible.
Yes, sir. Now you can share, sir, please.
Yeah. Yeah, now hope my slides are visible.
Yes, sir. Yes, sir.
Yeah. So today's topic is scope of patents and copyright. So we are generally from patent office background. We started as examiner of patents and design in the patent office Calcutta, and then afterwards I was promoted to assistant controller in patent office Delhi. We have in-depth knowledge about patents, but copyright is another office which comes as a sister organization under the same umbrella, that is Controller General of Patents, Designs and Trademark. But we will give you a brief idea of copyright also. So what you can do with IPR is you can become patent agent, any science graduate, patent drafting specialist, draft patent specification and claims. Since most of you are from science and engineering background, so you all qualify as patent agent, means you can appear in the patent agent exam if you are interested in this field of IPR. And further, you can also join government IPR office if you pass the exam related to for entry as examiner of patents and design. Moreover, we have patent valuers and patent analysts. Again, patent LPOs are there who file patents for foreign patent offices. So it is outsourced, patent job is outsourced, and that is by patent LPOs. So again, there are licensing specialists relating to licensing of patents. So there are diverse fields. Our office comes under the Ministry of Commerce and Industry. And under that, there is a department, DPIIT, which has our head is called Controller General of Patents, Designs, Trademarks, and Copyright. So we have these intellectual property offices under the same head. That is patent office at these 4 metros: Calcutta, Delhi, Chennai, and Mumbai. Trademarks at Mumbai, Delhi, Calcutta, Chennai, and Ahmedabad. Designs office is at Calcutta. Copyright office is at Delhi. Semiconductor IC layout design is in Delhi, and training academy is here at Nagpur. This is how our offices look like at the 4 metro locations. So this is the International Search Authority and Preliminary Examination Authority at Dwarka, Delhi. This is our institute at Nagpur. ipindia.gov.in is our website. You can go to the website and get the details about our current programs, about the programs which are offered by RG NIIGPM. You can enroll for the programs. You can get an idea. Time to time we post our programs there, our forthcoming programs. You will get to know about them, and then if you contact the office at our email address and mobile number, then you can enroll for the same set program on payment of the required fee. So this is how our website looks like. We are there on Facebook and as well as in Twitter. In spite of COVID-19, the progress of we have progressed. Our filing has increased. Our disposal has increased. Though there was a 2 years gap in between when our offices were mostly closed, but we did on work from home, and that is how we managed to file send so many examination reports for the so many patent applications, and also grant them or refuse them, dispose them. Currently we have disposed in 2020-21 28,300 applications has been granted. Similarly, trademark filing has also increased and their disposal has also increased. Copyright office also has shown increase in publication and filing and disposal. These are the figures of past of top 10 offices in 2019. That is the highest number of filing was in China, and India was 7th in the number of filing of patent applications. Patent applications at the top 20 offices was like this, and the majority of the applications were from non-residents in India, whereas you can see in China the most majority of the applications are from residents. So we want to file, boost up the resident filing in India, and that is why we have been giving some concessions, 80% fee concessions for startups and MSMEs, small and medium, micro, medium enterprises. We are offering fee concessions, 80% fee concession for institutes in filing patent or examination. So for institutes are getting this advantage, and 80% fee concession for institutes in patent publication fee, suppose early, and 50% fee concession for startups and SMEs in for design. That is this is for design filing, and fees concession is also there for ladies when one of the applicant is ladies. Suppose there are joint 2 applicants and one of them is ladies, then they are eligible to file expedited application for request for expedited examination. That is, out of turn examination is possible, and that is why you can file, and there is also 80% fee concession for ladies. Online filing is available nowadays, and video conferencing facility for hearing is available. When there is a hearing, when objections are outstanding, we no more call the agents and to come to our doorstep and come to our office and appear for the hearing as used to occur before. But during these COVID and Corona days, we have started video conferencing facilities so that the agent or the applicant's representative or the applicant himself, if they have applied, then they have to appear for the video conferencing, hearing through video conferencing. Again, there is SMS alert or notification once the first examination report is issued for the patent application, or the grant or patent is granted or being refused, or the report or the refusal order is being uploaded in the module. So instantly you are asked to provide a mobile number, and we populate the particular field of the mobile number, and then automatically the SMS goes from our system that FER has been issued, that is the first examination report has been issued, or the patent has been disposed, or the patent has been granted, or the patent has been refused. So again there is a reduction in pendency of chemical and biotech cases, and designs disposal in around 6 months if filed all document properly. So if all documents are filed properly within 6 months, a designs application can be granted and disposed of. Again, patent disposal is possible within a year. Yes, earlier it used to take 7 to 8 years. Nowadays it is reduced to 5 years, but still it is for the queue, examination in queue system. So if you file request for examination in Form 18, then you get a patent. It takes almost 5 to 6 years time. Otherwise, if I want expedited consideration, expedited examination means out of turn examination of your application. Your file will be examined on a priority basis. It does not have to wait in a queue. Then you have to file Form 18A that has 8,000 rupees fees, and Form 9 you have to file for early publication. That is the request for early publication with 2,500 rupees. So with 10,500 rupees, an individual or a joint applicant, where one of the applicant is ladies, are eligible to get a patent in a year, provided your patent is patent eligible. It qualifies in the novelty, inventive step, and industrial applicability, and also it does not fall under the purview of non-patentability under Section 3 of the Act. If these conditions are met, then you are eligible to get a patent within a year if you file these 2 forms, along with other forms like Form 1, Form 2, other compulsory forms you have to file them. But instead of filing Form 18, you file Form 18A, and instead of waiting for 18 months for normal publication, you have to file Form 9 for early publication, so that it is published within a month of the after filing of your application. 90% of refund is also available. If suppose you have lost interest in filing your patent application, in pursuing your patent application after filing the same, then you are also eligible to get 90% refund of your fees after filing your patent application. Again, online filing fees is 10% lower than physical filing in patents. Online filing fees is 10%. Physical filing is 10% more than the online filing fees. So we are offering some concessions for online filing. So as you can see, that Copyright Patents Act 1970, it was amended in Patents Amendment Act 2005. Similarly, Copyrights Act 1957, Copyrights Act was amended in Copyrights Amendment Act 2021. So Trademarks also has Trademarks Act 99, Geographical Indications has Geographical Indications Act 99, Designs and Semiconductor. So this is patent and copyright, these are all fall under intellectual property. What is intellectual property? It is a type of intangible property which cannot be touched or it cannot be exactly measured. So other forms of property like lands, buildings and cars, these form tangible property. They can be measured exactly. That is why they are called tangible property. So they are further classified into movable and immovable property. Now intangible property, intellectual property comes under intangible property. Intellectual property can be further categorized into industrial property and copyrights. And industrial property comprises of patents, designs, trademarks and geographical indications. So what does intellectual property mean? It is giving shape to creative ideas and expressions. So you have to give shape to your intellect. The product of the intellect has a commercial value, and that is why you get this. So you commercially exploit the product of your intellect, and that is why that is we encourage you. We encourage you to file intellectual property. We encourage you to file patent, and because it is intellectual property is an asset. So we encourage which can be bought, which can be sold, which can be licensed, which can be exchanged with others. And so like any other form of property, you can negotiate it and you can enter into IP-based, intellectual property-based agreements. So this is just like any other property, it is an asset, but it is not, it is an intangible form in nature. Why do we go for intellectual property registration? Is that so that to avoid the duplication of research, and so that we do not reinvent the wheel, we don't waste our time and resources for unnecessary things which has already been done by some other party. We can utilize the published patent specification. Like time and again people come and approach our institute, they go through our journals, they go the other day they came from CSIR and they examined all the applications related to the field of fisheries and all that, how many patents they have got and how many patents were filed during the period right from 2000 to 2020. So they are researching on that. So in that way, many people from many institutes, from government institutes or private institutes, they approach our organization, and they get an idea by studying the chronologically, because most of the patent journals are available in the internet, means in our website, but some from the 2000 to 2006, at that time it was Gazette publication. So at that time, Gazette publication are available with the individual offices. So it is available in our Nagpur Nagpur office as well. And again, transferring invention as public property. So patent is given for a period of, it is a monopoly right, which is given for a period of 20 years in exchange of full disclosure of your invention in the complete specification. So if you are satisfied that your invention complies with the definition of invention, means it is inventive, it is novel, and it has industrial applicability. Moreover, if it is not, if it does not fall under the purview of non-patentability, then we give it a patent. We grant it a patent. Now, after 20 years, this monopoly right ceases and it becomes a public property, which is available for all. Now, nowadays, all the faculties are being encouraged to file patents because it is an indicator of their achievement, and also not only the personal achievement but also an achievement of their institute. It is an indicator of the time and energy which they have devoted in research and development. So we always ask them that please do not publish it in your, before publication you please file a patent application. If you are at all, if you have plans or it is a patent eligible matter, then please file a patent application and then go for publication. Because once you go for, if you file a if you publish it, it serves as a prior art. And then once it serves as a prior art, we do prior art searches. As you file patent application, we do prior art searches. And if we find that the same patent, same application has already been published, then it proves as an anticipation or a citation, prior art citation. So if it serves as a prior art citation, it loses its novelty. Now when it loses its novelty, it is no more an invention, it is no more novel, or it is no more new. And so you don't get a patent for that same thing. That is why we ask that please don't publish it before before filing a patent application. First file a patent application, then go for publication of your journal in the whatever journal. Providing reward also, this is an exclusive right. A right to make, use, exercise, sell or distribute. You have this monopoly right to make, to use, to exercise, to sell and to distribute the invented product or process in India. And this right, this monopoly right can be shared, can be licensed and or can be sold. So encouragement, why do we give you this monopoly right? Because we want that more people come up with more inventions for the benefit of the society at large. So that is why we give this monopoly right. This is a reward for the intellectual ingenuity which you have put, or the time and energy which you have devoted in research and development. That is why we give this monopoly right. Similarly, you can make profits and earn royalty through putting the invention by licensing your patent or by technology transfer. Again, you can commercially exploit without fear of copying or imitation from potential competitors. So you can prevent competitors from copying or imitating because you have already filed a patent, you have already filed applied for a patent and got a patent granted in your name. In case you find that some unscrupulous persons are copying or imitating your invention, and then you can bring it to the, and then you can slap a notice in the national newspaper or a newsprint or media that it has come to your knowledge that so and so person has doing so, and so he should stop immediately. Otherwise, he is liable to face penal charges. And once you get a patent granted, then you have the every right to move to court and file a suit of infringement for your patent, and that against, and then the infringement has to be, means the defendant has to prove that he is not infringing your. So the burden of proof goes to the defendant. So by filing patents, you expand market share and venture into new market or in business. You increase the valuation of company and market value of company or institute, and you can through trademark, registering a trademark, you can create a corporate identity of yourself. Now, why is a trademark filed? The trademark is filed in order to distinguish the goods of one trader from that of other trader. So, in order to get a genuine product, we always, the user searches for a good trademark, a branded good. So that is why trademark is being registered. Negotiating, licensing, franchising, IP-based contractual agreements. Again, you can enter into these negotiations, and you have every right to initiate legal proceedings against infringement, particularly when you have been awarded with the certificate. Particularly when your trademark has been granted or your patent has been granted, you have the right to move to court. Before that, you slap a notice against him so that your patent is pending before the government of India office, and that you are and that the unscrupulous person is liable to face penal action, and there's a huge penal action for the losses being incurred and due to this copying or imitation, due to this infringement. So these are the different type of intellectual property, and how do we differentiate them? And invention, we give patent for inventions. We give for external appearance or the appeal of the article. We give designs. And for trademark and for the beauty of the product, we give designs, and it has nothing to do with the function of the article. The primary requirement of designs is that it has to be novel in nature, means it has to be new, and it should not be scandalous, and other things are there, and then it should be and design is given for a period of 10 years and is further extendable by a period of 5 years. So 10 plus 5 years. And trademark, can you see my slide, Dr. Jitendra?
Yes, sir. Yes, sir.
Yeah.
Yes, sir.
Yeah, and trademark is given for word, logos, and slogans, and so as to distinguish the good of one trader from that of other trader. And trademark, it is an automatic right. So suppose you launch a trademark, you do some initial searching, prior art searching, that whether regarding the novelty of a trademark, and then you launch the trademark in the market. So the moment you launch, your right comes into being. But in order to have some evidentiary value, in order to possess a certificate, you want to possess a certificate, then you approach the trademark office for registration. Otherwise, it is an automatic right. Trademark, copyright, these are all automatic rights. Suppose you do an artistic work which is novel in nature, which has the minimum modicum, means it has a minimum creative, it should contain minimum amount of creativity, minimum modicum, the copyrighted work. So when these at that time itself, that particular right comes into being, trademark, copyright. But in order to have some evidentiary value, in order to possess a certificate in hand, so that if some untoward incident occurs, some imitation or occurs, then you have proof in hand that you have, in order to seek remedy from the court of law, then you have a proof in hand that yes, you have a certificate, and that prima facie you have an evidentiary value. That is why you proceed to Copyright Office for registration. That is why we proceed to Trademark Office for registration of a trademark. Otherwise, the person who has who does not have a certificate, or even has not approached the trademark office, but has sufficient proof to show other proof to show that yes, this trademark is existing from 1980, then that will also do. But in order to seek legal remedy from the court of law, when your trademark is being infringed, or when your copyright is being infringed at that time. So that is what I am trying to say. And copyright is given for, trademark is given for 10 years, and it can be renewed every 10 years till any time. And copyright is given for lifetime of author, plus 60 years after death. So this is the thing, and geographical indication, and that is it is given for place names, and that every article, every product has a particular property, special property because of the place to which it belongs from. Suppose an Nagpur orange or Darjeeling tea, and these are special properties, and they are unique. The sweetness and that juiciness is attributed to the particular nature of the soil or the way it is cultivated or the climate of the place. That is why the group of traders in the place, they approach the particular office and seek a GI tag so that no other spurious product is being let off or sold off as that Nagpur orange, and eat away into the profit of the genuine trader, so that it will not eat away into the profit. That is why GI registration or GI tagging is being done for this. Similarly, a single product has multiple intellectual properties, can have multiple intellectual properties associated with it. Like a laptop or a notebook can have patent associated with its constructional features or its storage memory features or its processor. Similarly, the manual which comes along will be protected by copyright. Again, the brand name or the logo is protected by trademark, and the external design is being protected with the aesthetic value that is being protected by design and the design of this. So we have to, whenever a product is being launched, the person in charge has to be quite aware of all the intellectual properties associated with it, and there should he should note down all of them and seek wherever registration is necessary or required in order to avoid any unnecessary imitation of the product. He should approach that particular office so that to avoid any legal hassles or tangles afterwards. So this is when we search for a ballpoint pen, we can see that the earliest patent which was awarded to the pen, it was in 1939, and this is a US patent. And previously, before that, much earlier, 50 years ago, then that pen was you did not used to work on paper. You only used to work on wood and leather and not on paper. So accordingly, this Viro invented the pen and modified the pen tip, and he also modified the ink so that it dried quickly and did not smudge, and it could be written on paper. And previously, we only used to function on wood and leather. Now, this modified pen was working on paper. So it was last invented in 1939. Similarly, if you see on search, the easiest way you engineering graduates, undergrads can search for patents is in Google Patents, which is a worldwide database, free database of patents. And if you go and we enter the keywords here, you will get the search results here listed, and you can see the publication numbers. The individual country publication numbers. This is a Japanese publication number. This is a European publication number. So the same application has been filed in number of countries. Singapore, Taiwan, all the countries it has been filed. And the date of the respective publication number is also indicated along with that. So you are well aware of this car, which was launched by Tata in a few years ago, and it also had some patents associated with it. It had 31 designs associated with it and 37 patents associated with it. So patent is an exclusive right for 20 years from the date of filing. So here we say that not publish your invention before filing a patent application. Again, use of invention in public or commercial use of invention in public is prohibited before filing a patent application. And wait until the invention is fully. You don't have to wait till the invention is fully developed before applying of a patent, because you have to file if it is in intermediate stage. If you are
डिपार्टमेंट वाला आज आया था तो हमने भेज दिया ना
and you want to get priority, or you have the apprehension that someone is copying and will file a patent or publish it before you, then you go for provisional patent filing. You file a provisional specification of the on the date of, and you will get the priority from that date, and then you file a complete specification within 1 year from the date of filing of the provisional. If you fail to file within 1 year within the complete specification, then your provisional specification will be deemed to be abandoned. Will be treated as abandoned.
क्लब नहीं लिखा हुआ
Again, we don't
मुझे
ask
क्लब
for
लिख देना
any
है
prototype or model. You have to give the
जो भी
theoretical
होगा,
description of your invention. You have to give claims which will demarcate the exact right because to which it extends your so it has to be drafted by a professional, or even if you have mastered the art of claim drafting, then that is also necessary by going through our lectures. And if you want to know in depth, you should enroll for our paid programs also as well. So how a patent right can be lost is due to premature disclosure. As I said, if you publish it before filing, and employees disputes over IPR, sometimes the employees they divulge the details and they disclose the details, and they do not honor the IPR agreements which they have entered with their employers. And then failure to recognize by act of omission, commission, sometimes our contribution goes unnoticed, and therefore failure to recognize inventions. Again, problems with joint development agreements are there, and then we do not try to give adequate importance to intellectual property things, and that is why there are loopholes, and we leave out these things generally, and that is why these problems exist. So patent is given not for only for inventions and not for discoveries. So if you are finding a new thing or property of a known material or article, it is not supposed to get a patent. Invention means, according to the Patent Act, invention means a new product or process which has an inventive step. That is, it means inventive step means non-obvious, and it is capable of industrial application. So these three conditions have to be satisfied, which technically it will qualify as an invention under section 2(1)(j) of the Act. Again, an invention can be a new apparatus, device, process, or method. It should have an inventive step, or it should be non-obvious, and it should be capable of industrial application. Means it should be practicable. It should not be limited to abstract ideas. An invention is new or novel if it has not been disclosed in the prior art. As I said, it should not be earlier published. It should not be earlier presented or otherwise disclosed or exhibited to the public before the date of filing of patent specification. That means novel or novelty. Means you have our examiners search for prior art searches, and if they find any similar publication, be it patent or non-patent literature, then they give you a citation in the prior art citation in the report, and then if the prior art citation is significantly similar to your invention or your alleged invention, then you fail to get a patent. However, if you manage to show that no, there are significant differences over the cited invention, over the cited prior art, then you may manage to clear the novelty step objection. Similarly, inventive step is given for technical advancement. We have to show that we generally cite two documents in order to show that an invention, the particular alleged invention is lacking in inventive step in view of two documents, two cited documents. So if we combine the two cited documents, then this inventive step objection means is raised. But if we say that we can arrive at the invention when we combine these two citations, but now you have to reply to that objection. You have to say that no, even if you combine, or if you can say that in one document it does not lead to the other document, it goes away from the other document, and so they are divergent views, so it cannot be normally added. It is not possible to add the two different citations. There is no teaching in them to adding, or there is no hint of adding to the two, and that is why the lacking inventive step objection is not tenable, or does not hold good. So in this way you have to give your submission, otherwise it will be treated as lacking in inventive step and you will fail to get a patent for your alleged invention, for your invention. Similarly, the indications of non-obviousness are a surprising result, the solution to a long-standing problem, the fulfillment of a long-felt need, a great technical problem. So if you manage to show that these things, then only you qualify for non-obviousness. Similarly, each application is for a single invention. So again, if there are plurality of inventions also, then we ask you to divide the particular application and separate the claims of the another invention which has been clubbed together along with the main invention, and separate the claims and file a divisional application. Then the controller raises an objection that their claims do not have plurality of invention, and that is why, or the group of inventions not linked to single inventive concept. And if that objection is there, then you have to divide your patent application. And then as we classify the patent for ease in patent searching, prior art searching, we classify the patent initially, and then we also give and also for allotting it to different groups of examiners, because there are patent that each and every examiner is expert of different classification, and they have been classified into 4 broad groups, that is chemistry, biotechnology, and electrical and mechanical. So these are the 4 groups of examiners which exist, and the 4 groups have 4 group leaders, and under that there are these groups function in the 4 locations means 4 metros. And after I was saying you about section 2, and section 3 and section 4 teach about non-patentability. So non-patentable inventions in India. So you have to ensure after that your invention may be an invention, but it should not be non-patentable. If it falls under non-patentability, then even though your invention may be invention, but it will not be patentable. So when we don't give, then when it is against the natural laws, means a machine giving more than 100% output, or it is contrary to public order and morality, like method of adulteration of food, or method of cloning of humans, or device for housebreaking. Mere discovery of a scientific principle is also is a discovery, and so it is kept outside the purview of patentability. Mere discovery of any new property of a known substance is also kept outside, because discovery not patentable. Again, admixture means 2 drugs has been combined, and their properties will obviously be the combination of the properties of their composition of the components. But if you can manage to show that there is a synergistic mixture, means the property is something improved property after mixing the two, and then it is eligible to get a patent. And the method of agriculture or horticulture is not patentable. Similarly, diagnostic method or prophylactic methods or any medicinal or surgery methods is not patentable. Plants and animals fall under the purview of Plant and Animal Variety Act. Mathematical method or business method, if it shows computer program per se, if they show technical contribution to prior art, then they are supposed to get a patent. But if they are only, the output is a number, the output is only a program or a number, or and then it is then it is not, you do not get a patent for it, and we treat it under section 3K. Similarly, literary dramatic works are come under the purview of copyright and so not patentable. A mere rule of playing a game or method of performing mental act, like method of learning a language or method of teaching, is not a patentable matter. An invention which is in effect traditional knowledge. So traditional knowledge is also not patentable, because it is Ayurveda. It falls under the which has been passed to us from generations, and there is a huge database which has been made by the government at the initiative of the government. That database has been formulated just to oppose the patents which were granted for basmati, neem and turmeric in foreign jurisdictions. They were filing in Europe and in USA, and all these patents related to traditional knowledge. In order to oppose those patents, we have made the traditional knowledge digital library. So we have instructed all the examiners worldwide so that every country should check once they get a patent application that their application does not disclose anything which is in the database, in the digital library. If it falls within that purview, then they are not supposed to get, because it's a part of traditional knowledge. So then your invention becomes non-patentable. So they have also included, amended their act and brought into effect this particular section, so that's to avoid awarding patents to traditional knowledge. Can you see? No.
No, sir, it is not shareable.
So once a copyright application is filed, the same is published with the title of the work, the diary number and the title of the work. For 30 days from the date of the publication, the office waits for third-party objection. And after that, if no third-party objection comes, the application is examined on the basis of statement of particulars, that is the files, the forms which have been filed, and the author and owner. Now, author and owner, if they are not same, then they ask for an NOC. They raise an objection and ask for an NOC, and the NOC has to be filed by the author in favor of the owner. And as you know, this is copyright. Copyright is an automatic right. It comes into being along with the creation of the artistic or literary work. However, if one seeks registration certificate or evidentiary value, suppose you seek, as I said, that the trademark or copyright will come into being once it is launched into the market, or it comes into, it is fixed. You have, so fixation, I have written it down, that fixation means work should be published in some medium. So once you have fixed the work, then it comes into being. Because provided it has minimum modicum, means it has minimum amount of creativity, only then it can be copyrighted. So If it has if you seek a evidentiary value or then that is why you approach the copyright office to seek a registration certificate. Now, if there is copyright infringement, the aggrieved party or the plaintiff has the right to file the suit for infringement at the district court. Now, India is a signatory to the Berne Convention, and so if you are copying anything which is suppose a French TV is running something and you are copying the same and running in an Indian TV, then the French party has every right to file an infringement suit in India. And because we are a party to the Berne Convention, over 100 countries are signatory to the Berne Convention. So that suit can even be filed by a foreign plaintiff. That is a multilateral agreement which has been taken, and copyrighted application is not disclosed to the public against the as in the patent. In patent, unlike in patent, your application is disclosed to the public, but in copyright, your application is confidential with the Copyright Office. It is not in public domain. What we publish, what they publish is only the diary number and the title of the work. From that too, you have to make out that whether your work has been copied, and you have to see the other party, the third party has to make it out. So during filing copyright application for software codes, only the first and last 10 pages of the code need to be submitted in PDF format as per the Copyright Amendment Act 2021. So these are the few points regarding copyright what I could manage from our copyright sister office, sister organization. So if you have any queries, since time is very short and only I think 3 minutes are left. So if you have any queries, you can come forward and ask your query.
Dear faculty, if anyone having any kind of query, any kind of question, you can ask here. Unmute yourself and please ask.
I will also request you to fill up the feedback form, which I have already, Dr. Jitendra Pandey has already posted in the chat box. So please fill up the feedback form and all the participants, then only you were eligible to get the certificate from our organization.
I think there is no question, sir. And
Okay.
at last, yes, sir, please.
Yeah, please say.
Now I would like to thanks to one and all, and a special thanks to go to Mr. Nirmalay Sinha, sir. And actually, you have taken very wonderful sessions, and you have started from scratch to A to Z about patents. Actually, how to take initiative for patent and how to follow the process. And even me itself, I just came to know we can do patent on ballpoint pen also.
Yeah.
We write every day, but we hardly think about that.
Yeah.
So once again, thank you very much, and we hope once again we will meet here itself.
Yeah.
So thank you very much, sir.
Thank you.
Thank you very much.
Thank you.